It can be argued that the reproduction of works is one of the most common forms of direct infringement of copyright. Have you ever played a DVD disc through your computer or DVD player and considered yourself to be infringing copyright? In 2001, the federal court considered whether copyright in motion pictures, which were embodied in DVDs, would be infringed by a person who rents and plays a DVD with those certain motion pictures, whilst doing so without a license. The decision of Australian Video Retailers Association and Warner Home Video determined that the mere playing of a DVD and the brief expression of visual images and sound contained in the RAM of a computer or DVD player does not unequivocally constitute the act of making a copy of a film under Section 86, subsection A of the Copyright Act 1968. After initially being brought before the court by the association and its members for alleged threats of copyright infringement, Warner claimed for infringement in relation to the rental of its DVDs, in particular the Bait and Romeo Must Die DVDs. They attempted to establish that the means by which the DVD was played, including the sequential decompression of the audio, video, and caption content and storage in the RAM, that consumers did in fact make a copy of the whole or a substantial part of the film embodied in the DVD by playing the DVD itself. The issue in this case was whether the playing of the DVD discs constituted the doing of the act referred to in Section 86, subsection A of the Copyright Act. The contention could be considered advanced due to the fact that only a small fraction of the audio, video, and caption content is stored in the RAM. Warner relied on the fact that the playback of a DVD occurs by passing the film to the RAM of the DVD player or computer, thus creating a copy of the film. The court ultimately held that neither the whole nor any substantial part of a film could ever be completely embodied in the RAM of a computer or DVD player. Therefore, under the Copyright Act, an individual cannot make a copy of the film by merely playing a DVD. Another issue Warner raised was the extent to which copyright existed in computer programs contained in the DVD. To be a reproduction, there must be a reproduction of a program in material form, and it must be in a form of storage from which the computer program, or a substantial part of it, can be reproduced. It was concluded by the court that the computer programs subsisting in Warner, which are embedded in the Bait and Romeo Must Die DVDs, comprise only so much of the material contained in those discs as consists of program that result from the authoring process. Therefore, the protection under the Copyright Act did not extend to cover the content that was reproduced as a result of the execution of the computer program. The decision of the federal court in this case is significant and important, as it suggests the courts intend to take a practical approach to determine the limits of the rights afforded by the Copyright Act. Therefore, it is unreasonable to conclude that consumers would be making a copy of a film under Section 86, subsection A of the Copyright Act by merely renting and playing a DVD.